KCC docketed action, presumably, and this would allow utilities and others to a forum to present and have a discussion on general wildfire risks in the state, utility readiness and strategies to mitigate those risks, and then a discussion on cost recovery treatment for mitigation costs that are incurred by public utilities with regard to wildfire events. And Mr. Chair and members of the committee, if this bill is enacted, it would take effect on July 1, 2025 upon its publication in the statute book, and I'd be happy to stand for questions.
Okay, Nick, great job as usual. Senator Bowser's got a question here.
Thank you, Mr. Chairman, and thank you, Mr. Myers, for your expert testimony there explaining that. Question around the punitive damage award, the cap of $5 million. Would that include loss of life or no?
So punitive damages cap is only pertinent to punitive damages in civil actions are only applied when it's willful, wanton, reckless conduct on the part of the negligent actor or the tortfeasor. So that would only be if the utility is reckless in their conduct, where the punitive damages cap would come into play. I'm blanking on the term, the tort term, an unlawful death, well, because you're getting at an unlawful death action. Let me find the correct terminology in statute. But that would be, I mean, that would be its own
something separate.
A separate claim, and a plaintiff could still recover. I mean, this bill isn't prohibiting that type of an action, so a plaintiff still could recover damages, both economic damages, non-economic damages, and then also seek punitive punishment damages for those claims.
Senator Thompson.
Thank you, Mr. Chair. Nick, memory's the first thing to go. Trust me on that one. Are there other states that place a cap on these kind of situations? I know, like California, PG&E, they didn't clear out a bunch of brush, and they've been clearly negligent out there. I didn't know if you are aware of other states, what they do.
So there are, yes, there are some states, and now I don't have a full list of it, but I am aware of, I know one in particular, Utah has a statute somewhat similar to this, but the Utah statute does limit, it describes how to determine property damage in these fire claim events for public utilities. It also sets a non-economic damages cap that can be applied in those fire claim events. So Utah has a statute on the books, and I think there's some other states as well, and maybe some of the parties would be aware of that. Now, I will note on the Kansas books, there is currently or in Kansas statutes, there is currently a non-economic damages cap that's applied in the statutes. And I think currently it's a $350,000 limitation under the Civil Procedure Code. Now, there was a Supreme Court case recently, the Hilburn case, that found that non-economic damages cap violates the right to a jury trial under Section 5 of the Kansas Constitution Bill of Rights. That cap doesn't necessarily apply under that Supreme Court decision. So there's some other statutes that also are playing into this under Kansas law, but for other states, yes, there's some. Specifically, I know of Utah, and then there might be others.
Thanks, Nick. Thanks, Mr. Chair.
Committee, we have any other questions? Nick, thank you.
You're welcome.
Okay, oral or proponent oral, we got Mr. Chuck Casely, Executive Vice President, Chief Customer Officer for Evergy. So Chuck, welcome to committee.
Thank you, Mr. Chairman, Ranking Member Francisco. It is a pleasure to be back here. I hope that my testimony here is as short and as simple as this bill strives to be. It's just a little bit over a page. And mostly what it does is codify existing common law into the statute. So just real briefly, the federal government through FEMA defines wildfire risk across the United States. And if you look at our written testimony, you'll see that a significant portion of Kansas is designated by FEMA as either moderate or high risk for wildfire. And in states, other states where they have had wildfires or they are currently experiencing wildfire, have those risks, you see legislation of this kind passed where they deal with what the applicable legal standards are and sometimes put in caps and other things. Those states include California, Oregon, Washington, Colorado, Idaho, and most recently, as the reviser mentioned, Utah has passed legislation. This bill really does just two things. First of all, it requires the Kansas Corporation Commission to convene a workshop and to discuss this issue. There are a lot of things in the law and in regulations around utilities right now that are just wide open with respect to how a utility should handle this potential threat. And rather than us kind of in a silo make decisions that will impact the economy, will impact businesses and customers, we think the best thing to do is to get together in front of our regulator and have a full discussion with all stakeholders involved so that everybody can be part of talking about how the state should address this issue. The intent would be that before July of 2026, we would have these workshops, everybody could participate, we could assess the risk that both the commission and stakeholders believe that exist for wildfires with respect to utilities, the state of utility readiness, as well as any mitigation strategies or cost recovery as a result of those strategies that need to be addressed. There's lots of things that utilities can do other than not serve customers. So we can't mitigate our risk by not serving customers, but there's lots of things we could consider. So for example, in other states, they have now what's called PSPSs, or public safety power shutoffs, where if you reach a certain drought level and a certain wind level, the utility shuts off power to those areas. That's something that arguably we have the power to do today, but imagine the disruption that that would cause. Before we were to take an action like that, we would rather go in front of state regulators and give everybody a chance to have a conversation about it and say, what are the criteria for something like that? Do we think we should do something like that in Kansas? Other examples of potential mitigation are expanding the easements underneath our power lines so we have greater ability to clear out, as Senator Thompson talked about, brush. But again, that gets into property rights. And now all of a sudden you have folks that care a lot about whether that easement is 10 foot on either side of a conductor or 30 or 40 feet, for example. Again, that's something that should be discussed. So it's those types of things. Tree trimming is another thing, just how much we cut the trees that are in easements today. All those are things that we think are best suited to have and to be done in front of stakeholders where everybody can have a voice and everybody understands what the risk is, what the cost of those strategies would be, and we can resolve them that way. The second thing that this bill does is essentially take what the common law is of the state today and codifies it with respect to utilities and wildfires. So the standard of conduct that we have today is that under common law in this state, is you would have to establish through simple negligence which is a preponderance of the evidence that a utility act or inaction caused a fire. That's what the standard would be today. We would like to see that in statute so that there is no debate over that. The second thing that exists today is a punitive damages cap of $5 million, but it's broadly applicable. Again, we just want to put it in state law that says it applies to this specific situation. What this bill does not do is limit economic damages. It does not limit non-economic damages. So the ability for somebody to be compensated by a wildfire that we caused is not diminished by this bill. All it does is codify existing law and existing limits. Then the only other thing I would say is that as we went through this, there were some groups that were concerned. There were some ag groups that voiced concern about some of our definitions. We've worked with the ag groups and resolved that. I believe they will be testifying neutral today. And then also as we went through the House process, we noticed some cleanup around language that has to do with the negligence standard that I think we've vetted through these groups, and we're probably going to ask this committee or this body anyway to consider a very small amendment to one section. But at the end of the day, this is all about the ability to put up the rules around how utilities handle these situations and to put into law what the common law already says regarding the standards for utilities and liabilities around wildfires. And with that, Mr. Chairman, I would stand for any questions that you or the committee would have.
Okay, thank you, Chuck. Committee, you got any questions for Chuck? Senator Bowser.
Thank you, Mr. Chair, and thank you for your testimony. I note that the bill says public utility, but I'm wondering, would this also apply to electric co-ops? Probably not, I guess, huh?
I believe that the way it is drafted, it could. Do we? I think it probably would, yes.
Okay, that's helpful to know.
Yep.
Thank you.
Senator Francisco.
Thank you. And thank you, Mr. Kaisley. So this act would take in effect on publication in the statute book, so that's July 1st. If, I'm guessing if we have this workshop by the KCC, they would probably have to start planning before that date.
That's right.
And I'm also wondering if we do get an affirmative commitment from the Corporation Commission that they would hold such a workshop. This is a really good way to ask for it, but I'm not sure that it makes sense to put this in our state statute forever, and we might not come back to this to take it out. So if you had a commitment, or if the utility committee was able to get a commitment, would you object to having that removed from the?
I don't think so. I think that the big thing for us is we want by a date certain to understand that we will address these issues, because these are decisions we don't want to make in and of ourselves. And I think there's also an argument to be made that if we took it upon ourselves to shut off power under whatever criteria we came up with, absent some kind of a regulatory opinion on that, I think you could get the yin and the yang of the situation would be somebody who got their power shut off could say, well, you caused me economic damages by purposely shutting off the power. So we don't want to get caught in that trick box. And we really do think that the best place to convene this, where they can look at other states and then look at Kansas's unique situation, is before our regulators here.
Thank you, Mr. Chair. I think having that workshop makes a lot of sense, and having a report to this committee next year about that workshop would also make a lot of sense.
Okay, oh, Senator Peck.
What do you mean, oh, Mr. Chairman? Thank you, Mr.
Called on you
Chairman. I
first.
appreciate that. Okay, a one-time workshop. Why just one time? Why not every 5 years, 10 years, something? Because there will be a change in personnel at the electric companies, whether it's a co-op or whether it's a big boy. I'm somewhat in agreement with Senator Francisco, which makes me nervous, but but I did find it interesting that put in statute, convene a workshop by this date, and then that's it, no more workshops. I'm also curious as to, is this going to increase, reduce the liability? Because someone can say, well, you in your workshop had this discussion and then you did not follow. Couple questions.
Yeah, sure. Great questions. So nothing in this is meant to limit the ability of the commission to have additional workshops. And again, pursuant to what Senator Francisco said, I think they have the authority to convene that at any time. And upon their commitment that they were willing to take a look at this, I don't think this would necessarily have to be in state law to do it. And by the way, there's nothing unfriendly about us putting it in the law, just more or less so everybody could agree that by a date certain, something should occur. So additional ongoing, I suspect when we say workshop, it's not really meant to be one moment in time. There'd probably be a series of meetings, lots of folks and discussion, potentially some rulemaking out of it. Nothing would prohibit it from going on in the future, and I don't think periodic reassessment of that would necessarily be a bad idea. So I think that was your first question. The second question, which is, does this increase or reduce liability? The answer is yes. It increases it in some circumstances, and it reduces it in others. So, for example, right now, somebody, a plaintiff's attorney, could come to Kansas and they could say, well, look, in California, in Oregon, in Colorado, all of the utilities have public safety power shutoff rules. You don't here. Therefore, you're negligent. You didn't do something that's a standard in all of these wildfire states. The problem is if we enact that without some kind of a regulatory authority, I think we would be increasing the chances that if you as a business owner have your power shut off and it causes you damage, we get sued for that. So we're kind of in a trick box where nobody's ever opined in Kansas what we should do in Kansas, and we don't think it should just be us to do that. Now, the flip side is also true. If, for example, the result of this workshop was them saying, you know what, in order to reduce wildfire risk, again, as Senator Thompson referenced, within your easement for your lines, you need to trim every 3 years, and we don't trim every 3 years, then that would absolutely increase our liability. What we like about this, though, is at least we would have the rules of the road, and that rules of the road would be set by a regulator who's knowledgeable and can look at other states and then apply Kansas's particular circumstances. And it also gives every other interested party a forum to come in and say, I think this is what we should do. Again, just going back to tree trimming, we could have an engineer that says, look, if we trim trees to a certain level, a certain number of times, we can reduce our wildfire risk by X percentage. Well, that's one perspective. Now, every single solitary property owner that has trees and that easement is going to be affected, I sure think it would be appropriate for them to come back and say, well, the opposite side of that is this is the side of that, you know, could be impactful to us. The other thing that people may want to talk about is increasing tree trimming is necessarily going to increase the amount of money we spend on doing it, which will impact rates. And so all of those things need to be balanced, and that's why having this workshop where it's discussed and everybody has an opportunity to say, this is what's right for Kansas, not just what some lawyer sees done in California, is the right thing to do in this state.
Thank you, Mr. Chair. Thanks, Chuck. You know, this storm just passed through, 60, 70 mile an hour winds. Do you have any data? I mean, I'm sure that caused some problems, not negligence, but just natural type situations, changes in the drought patterns, things like that nature. Do you have any data on how often wildfires are caused by a down power line or something like that? I'm just curious, is there just a higher risk, or people become more litigious, or the combination of more frequent type situations? I'm just curious.
So that's a great question. I don't have any data on it countrywide. What I can tell you is that we're not aware of any wildfire that was caused by downed power lines in our service territory. We have had some isolated fires over the years where a line would come into contact with something and start a fire, but nothing that rose to the level of a wildfire. What I will tell you, and what one of the clear intents of this bill is that there is this legal concept known as strict liability, which basically means the business you're in or the conduct that you're doing is so inherently dangerous that you don't need to show that it caused something. If there's damage there and you're kind of in the vicinity, you could be held responsible for it. That's what's going on in California right now. So even this morning, Los Angeles County has filed suit against a utility there, and they don't have anything that points to the fact definitively or even by a preponderance of the evidence that the utility caused it. But what they're saying is, in absence of anything else, and given the fact that what you do is inherently dangerous, we're going to hold you responsible. That's not how Kansas approaches it, and what we want to make sure is no out-of-town lawyer essentially comes in and says that, because then what happens is the lawyers make a lot of money, and that cost, in the case of California, has driven that company into bankruptcy. Now that's going to affect every bit of capital investment we do here, which it'll raise the rates of, for getting capital, access to capital, and it'll cause rates to go up. If we're negligent, we should be held responsible. You shouldn't have a cap on economic damages. We should have to pay for non-economic damages. What we don't want to have is somebody come in and say, well, look, you guys are a dangerous business. We can't show that something you did caused it, but by gosh, you're there, we're going to hold you responsible.
Makes sense. Thank you, Mr. Chair.
Committee, we got any other questions? Senator Warren.
Thank you, Mr. Chair, and I apologize to the chair and the committee and to our conferees for being tardy today. There was a meeting that went later than expected, so I apologize if this question has been asked and answered. Regarding the amendments made by the House Committee, were those amendments agreed upon with the proponents? So these were requested amendments by the proponents that were made in the House Committee?
Yeah, we worked, there were some agricultural groups who were concerned about some of the definitions. There were some members in the House Committee on both sides that wanted to tweak the language, several lawyers. I'm a recovered lawyer, so I can admit to having that predilection myself. But no, they were all friendly, and it was all designed to get to the point of really, we want to workshop and we want to take what is state law through common law and just make it statutory.
Regarding one of those specific changes on page 1 in line 21, it's been changed when the statute of limitations start from the date of the ignition when the fire started to kind of a when did you discover your damage from the fire event? And that's intentional on the part of the proponents to have that change included?
Yep. We think, again, that was a change, I believe, requested by Representative Carmichael. We discussed it. It's in several other places, both in common law and the statute, and that was something that was acceptable to us, yes.
Okay, because damage could be discovered far past 2 years. So.
It could, and I think the discussion lent to the fact that it, known or should have known, and there's a hard cap, I believe, at 10 years that exists under the common law today. I bet you the revisor could probably tell me. Yeah, so it's statutory. See, so we're aware of that, and look, would we like it to be a hard 2-year? Probably, but is it fair that if somebody discovers some damage at some point and can show that they wouldn't reasonably have known about it, we're acceptable to that.
Thanks for answering. Appreciate that. Thank you, Mr. Chair.
Committee, we got any other questions? Okay, thank you.
Thank you, Mr. Chairman.
Next, we'll have Eric Stafford, Vice President of Government Affairs, Kansas Chamber. Eric, welcome to committee.
Thank you, Mr. Chairman and committee members. Good afternoon. Eric Stafford with the Kansas Chamber, and appreciate the opportunity to be here in support of House Bill 2107. Seems like a good consent calendar bill, if I had to say so myself. But I'm not an attorney, but my wife watches Suits, so I've picked up some tricks, and ultimately, overall, this bill, I think if anything provides certainty. Evergy's not unique compared to any other Kansas business that when you talk about legal climate and certainty that they can be provided through the law. That's ultimately good overall for consumers and also for the company. We are following their lead on the conversations that have continued to take place, but everything that they've been working through with other interested parties appear to make sense in the changes and clarifications that they're asking for. So overall, we do feel like this provides some good protections for them. Chuck mentioned the process that working through with the KCC and his example about attorneys potentially using negligence for not having an established shut-off policy, and that could be a problem. So we believe that is also a good step to take just in terms of setting a state policy for how to address fires caused by utilities. So happy to answer any questions, but we believe this bill's pretty straightforward and reasonable. So thank you for the opportunity to be here.
Thank you. Committee, we got any questions for Eric? Senator Francisco.
Thank you, Mr. Chair. So if we amend it, it's not eligible for the consent calendar?
Oh, yes, I wasn't thinking about that. Yeah, fair point. Well, maybe we don't. No, just kidding. Yeah, just kidding.
Senator Thompson.
Thank you, Mr. Chair. My wife and I watched Suits until she noticed that the guys were all pretty good looking. So. Thank you.
Did you cut your Netflix subscription?
No questions, just yeah.
Does the committee have any other good questions?
I'm here all day, Mr.
Okay, all right. Okay, here we go. Senator Clifford.
Hey, Mr. Chairman, I think I do have a good question. I
Okay.
just am concerned that this requirement to have a meeting of some sort might set a precedent, like, double the poles across the Flint Hills so that, the wires don't come down, and then that would be a basis for suit because they didn't follow the recommendation. Any thoughts about that?
Mr. Chairman, I might defer to Chuck. My thought would be, I think this is a unique situation because they are regulated through the KCC. And I think that's where they're looking for guidance from their regulatory body on how to handle these situations. I think that's the reason why that's brought in there. It is a little unique. You wouldn't necessarily open up workshops through a agency in statute otherwise in other areas. I'm trying to think like a legal liability type of situation, but I think it's unique because the KCC is the regulatory body overseeing utilities.
And follow up, then those recommendations, and maybe it's for Chuck, it seems like an expensive recommendation might even trigger a rate case then, if you're going to have to take all the transformers down across X area.
Yeah, so to the first question, Eric was absolutely right. I mean, we only authorize, we only do what we're authorized to do, and so getting some guidance on this would be good. In the workshop, there would be a lot of opinions that were probably given, but the standard of what we should do would be set by the regulators who are the ones who set our standards on everything, whether it's reliability, whether it's customer service, so that's why we feel comfortable with that. And yes, if we didn't follow those recommendations, it would be difficult for us. The second thing is, could it cost more money? Yeah, it could. So would you rather have us in a vacuum, with no advice saying, well, this is what we think we ought to do in order to mitigate our risk, which we might go further and be even more expensive because, an entity wants to mitigate as much risk as it can financially, or should we have it in front of a regulatory body whose job by definition is already telling us how to operate, hear all sides, and then say, this is why for Kansas, this is the right thing to do. And I'll be very transparent. There are differences even in the two states that we serve. So we have one set of tree trimming rules for Kansas and one set of tree trimming rules for Missouri. And Missouri is a little bit more aggressive. And so Missourians are paying more for the vegetation management there. Kansas is a little more sensitive, both to cost as well as we really like our trees in Kansas. And so where it's not federally preempted by FERC, we're a little more lax. What I don't want to have happen is us decide to keep doing what we've always done for tree trimming in Kansas and have somebody from Colorado or somebody from Oregon or somebody from California come in and say, you're doing it wrong because this is the new standard.
Thank you. And I don't let my wife watch Suits, Mr. Chairman. Thank you.
Hey, committee, any other questions? They're kind of lit up today.
Ice cream day.
Surely they got one for Eric here to get him going.
All done.
Any other questions? Okay, thank you, Eric.
Appreciate it.
Proponent written, we got 3 of them. We got one from Midwest Energy and we got one from Kansas Electric Cooperatives. We've got neutral written, that's from the Kansas Corporation Commission in your file, Kansas Farm Bureau, and Kansas Livestock Association. So I don't think we have any other, is there any other proponent, opponent, or neutral testimony that want to present at this time? Okay, if not, there is a fiscal note that's in your file, committee, and we'll close this hearing on HB 2017. And I think we have time to work on this one. 2019.
You just said 27.
Okay. Okay. So we're closing the hearing on HB 2017. Yeah. Okay. 2117. I got a typo here.
2107.
See, that's why it's nice to have her around. I'm telling you. So 2107. Okay, so we're closing the hearing on HB 2107. So what I'd like to do at this time is open final action on HB 2019, if you have that in your file. 2019. So you got my 21.
2109.
That's got a typo, okay. 2109, here we go. Busy as Susie's been, I'm surprised there isn't more of that, that's what I'd say. So at this time, I'd like to have Nick come up and give us a brief overview on this, Nick, if you would, or you can do it from back there.
Yeah, thank you, Mr. Chairman. Committee members, if you have it's House Bill 2109. This is the law enforcement and public utility pole attachment bill. And this bill, as you will recall, would require any public utility to enter into a pole attachment agreement with a law enforcement agency upon the request of the law enforcement agency. And then there's certain requirements that would be set forth in this pole attachment agreement, including identification of the poles where that equipment would be attached, the nature and type of the equipment that will be attached, the utility safety specifications for that attachment. There would be a provision to grant the utility the sole discretion that the attachment and operations regarding that equipment be done by the public utility or a qualified contractor approved by the public utility, and then also provisions relating to indemnification of the public utility from all liability relating thereto. And Mr. Chairman and members of the committee, I'd be happy to answer any questions if necessary.
Okay, thank you, Nick. What kind of vote was it over on the House side?
We'll get that for you here in just a second.
Okay. Does anybody else have any questions for Nick at this point? Senator Warren, you got one? Okay. Anybody else? Okay, no questions. At this point, I'd say, what is the will of the committee on this bill? Senator Thompson.
Thank you, Mr. Chair. I believe it was unanimous on the House side, as I recall. I think. Don't think so?
I don't know. Senator,
Okay. Then I won't put it on the consent calendar, but I would move, I would make the motion to pass out House Bill 2109 favorably.
okay, do we have a second? Then we'll have discussion. There's a second by Senator Clifford. Now we'll open up for discussion. Okay, I think we've discussed that one out pretty good.
Mr. Chair.
Okay, you got, Senator Warren.
Thank you, Mr. Chair. I do appreciate what the intent of the bill is, and it is to provide law enforcement some additional tools. However, after our robust discussion on the bill yesterday, which I also appreciate, I still have questions about it that haven't been answered to my satisfaction anyway. It starts off upon the request of a law enforcement agency. So I looked up how was law enforcement agency defined, and it's defined in actually our rules of evidence, chapter 60, 473 regarding peer support counseling, I think, for law enforcement. And the particular definition of law enforcement agency is the following. Any public agency that employs law enforcement officers. So does that mean you're a public agency that, anyway, that's the definition. To me, that seems a bit broad. And I asked for other examples where we are having one unit of government. I guess it would be a public agency, right? So that would be any public agency that we have a public agency requiring another entity to enter into an agreement. And it just seems by definition, well, is it really an agreement if the two sides aren't free to discuss what the terms are going to be, or even free to walk away from any agreement at all. And the other question I had was if there's a dispute once an agreement is entered into, because our utilities that we heard, they want to be good partners to law enforcement too. So I understand, again, the intent of the bill and to be fair to everyone. But if you enter into one of these agreements and there's a dispute, where is the dispute resolution to be resolved? Is it through CURB? Is it through the KCC? Is it through the courts? So just had some questions about that as well. And perhaps our House counterparts didn't. It received broad support there, I understand. And then also the aspect of, well, we're putting security cameras on public spaces. And yes, you're in the public and you have an expectation that you could be viewed by others who are in the public. But what's the expectation of, are you going to be on a camera placed by law enforcement? So just some questions that I have. I, again, understand the intent of the bill, and it was said that a warrant isn't required to place these cameras. And so just a lot of questions. And I think until I can get those questions resolved, I'm probably have some hesitation about the bill. So, but thank you for the opportunity to share those. Thank you, Mr. Chair.
Nick, do you have anything that you can work on that part, or anything as far as any of our questions to that you can think of at this point? Okay, Senator Thompson.
Yeah, just a quick question, discussion with Senator Warren. Would you feel more comfortable if we changed on line 8, change the shall to a may? Because the shall would not absolutely require, but it allow them to enter into the agreement, but doesn't force them to do so.
Thank you, Mr. Chair. That would help. And, I'm not trying to, it's been worked on, I understand, between our law enforcement community who worked hard on this, and I know our utility partners want to be good partners too. And, that may help. It just strikes me as odd, and I think we asked, do other states have this? I mean, this would be a statewide policy. Do other states do this, and does it work? Is it effective? Does it cause problems? So it may help, but
If the chair desires and wants to answer the questions, I will withdraw my motion. Rather than trying to advance this, I'll leave it to the will of the chair.
I'm thinking we have a motion and a second, and if there's any cleanup that we can do to it, we can do it later, so kind of my opinion.
And
And see how the vote goes here.
Okay, I won't, I'll leave the
We'll
motion
just leave
in
it like
place.
it is.
I'll leave it intact. Thank you, Mr. Chair.
So we had a motion, a second. Any more discussion? Senator Warren.
thank you, Mr. Chair, and thank you for our the work of KLRD. And there is a response to the question about, do other states have these kinds of agreements? And the response from KLRD's research is no other similar legislation has been introduced or implemented in any other state relating to utility pole attachment agreements with law enforcement agencies. So just, provide some caution that if we're going to enact policy, we want to get it right. We haven't seen how this arrangement has worked in other states and how it would work here. So thank you, Mr. Chair.
Senator Francisco.
Thank you, Mr. Chair. I'd be hesitant to change the shall to may without knowing from the proponents of the bill how that would affect the liability. I thought we heard some response to the question that it hasn't been adopted by any other state because they're not aware of other states that have had litigation that would make the utility companies hesitant to go through with this. But I will follow whatever the maker of the motion does.
Mr. Chair, Kate Smeltzler, KLRD. Hi, just a quick comment. Upon looking into other states that have this sort of legislation. I was unable to locate any legislation that specifically said utility pole attachment agreements with law enforcement. There are states that do have warrant agreements, but beyond that, there are other state and federal trials that I'm looking into as well. So I should be able to provide some more detail, hopefully at a little bit later. But there's some more information behind this.
Yes, I like the amendment. It's permissive. It doesn't spoil the bill. We're intending to try to protect the utilities from liability. I also would accept on page 2 the definition of law enforcement agency. I realize it's broad, but certainly satisfies my curiosity about whom we speak. So certainly in favor of the amendment and the overall bill. Thank you.
Senator Warren.
Thank you, Mr. Chair, and maybe we just need a little bit more time to discuss the bill rather than
Vote on it.
moving on it today, but
Okay. Senator Claves.
Is there any chance we could, there might be somebody here that would be able to help with that in the audience that we know of? Mr. Casely, do you know anything about this? Yeah.
So I don't want to get into the middle of this may or shall kerfuffle, but I will tell you, Senator, that last year that was the very issue that stalled this bill out. So it was amended to may, and that there are a lot of parties that did not like that change. I do think if this committee and if this body gives us protection from liability and that's the law, then I think we're protected. Some have made the argument, though, by making it a choice whether we do it or not, that could throw that into jeopardy. I think if it's in statute that if we allow it or don't allow it, that we're probably okay. But then I know from, House leadership, law enforcement, and other folks, they much prefer the shall. They want to say if we meet these criteria, we can do it, and not have any pushback. We don't give a lot of, we do right now because we've been sued over it. But otherwise, we would want to help as suggested by several folks here. But the liability is the issue since we've already been sued because of it.
Senator Thompson.
Thank you, Mr. Chair. Rather than try to force the issue when it seems like there's a lot of folks on the committee with questions, I think it'd be wise for me to withdraw my motion at this point until you have a chance to circle with everyone and see what issues may need to be resolved first. That just try to help out with that, Mr. Chair.
Okay.
I will withdraw my second.
Okay. Withdraw a second. Any other discussion? All those, we voted on that then. No, we don't need to. Senator Bowser, do you need?
Oh, thank you, Mr. Chair. I'm in agreement with Senator Warren. I need a little more time to think about this, and I would appreciate Senator Thompson's motion.
Okay, so we'll table this for now, and we will take and take it up at a later date, and at this point, we'll adjourn the meeting. Thank you.